Liberty Nation with Tim Donner.
And now we welcome you into the portion of Liberty Nation Radio, which we entitle Talkin' Liberty, as we welcome back in our regular contributor, constitutional lawyer and LibertyNation.com legal affairs editor, Scott Cosenza. Hello, Scott.
Hi, Tim.
Good to have you back. So let's start with one of the issues of the day, gays and trans and their inclusion in the Civil Rights Act at the Supreme Court. You wrote about this.
Big week at the Supreme Court, Tim. Their first week back from their nice summer vacation. And big case the first week, which is the Civil Rights Act of 1964, which prohibits, in matters of employment and other sort of associated areas, discrimination based on a number of factors, including national origin, race, and, yes, sex. Now, the question is, presented to the court, is gender identity a part of sex, and is sexual orientation or preference, depending on your preferred verbiage, also included in that prohibition, in that word sex? Now, clearly, when the law was passed, we know that none of the people who were voting on the law thought that that was the case. The drafters of it didn't think that that was the case. But that doesn't matter in terms of the analysis for a number of the justices. In other words, what's important for that analysis is, under today's reading of the law, can a person be discriminated against because of their gender identity or their sexual preference, and have that not be about sex, is how the question is couched before the court.
Is this a movement that can be held back? I mean, isn't it just inevitable that the law will recognize gay and trans as the same thing as gender, sex, whatever you want to call it?
Well, I don't know that that's true. Let's recall that the Obergefell decision, which decided that gay marriage rights were incumbent in the 14th Amendment since its passage, was a 5-4 decision. And one of the five that voted in the majority was Justice Anthony Kennedy, who is no longer on the court. So his replacement is Justice Kavanaugh. And we have to think, well, would Justice Kavanaugh vote the same way that Justice Kennedy would? We also don't have Scalia, and of course, Justice Gorsuch has replaced Scalia. So the vote counts get kind of interesting there, Tim.
I like to widen it just for a second, because you mentioned, okay, Kennedy's not on the court, Kavanaugh is. So in your view, my view was, as we've discussed, that it wasn't going to be that big a difference after all, for all the fuss about Kavanaugh. So what is the difference between Kennedy and Kavanaugh, the way you see it?
Well, Justice Kennedy was seen by those of us sort of paint with broad brushes, I think, for the ideologies of these justices was, he was best described, I heard, as a California Republican, okay? That's sort of libertarian light, I guess, sort of easy hand when it comes to government. But the inclusion of a sort of this kind of right for again, the California word there becomes important because, of course, them leading the pack in terms of recognition in both legal and just societal ways, LGBT people, that well, maybe that argues for Kennedy is going to be more liberal on this issue than Justice Kavanaugh. I know that Justice Kavanaugh is a Catholic and has closely identified with that religion, which has prohibitions against basically LGBT behavior and identity even, and so that may bear a strong part to play. I can tell you that outside of any cultural concerns, just legally, I think there's great cause to be made for not including these classifications in that law. I think that it makes sound policy and sense to not kind of reverse engineer laws to mean later on what I think wish they might mean, or what some people would wish they might mean, and rather, if that's where society is and this is a right they want to confer and convey, then that should just be done by passing. We don't have to add one sentence to the Civil Rights Act of 1964, which is to say expressions of gender identity and same-sex preference or orientation are now included on this list. That's the sentence that needs to be added, and then it would be done, there would be no interpretation issues about it.
Right.
But instead, and I'll just, Justice Scalia often talked about it was not a good move for society to have all of our rules be decided by one or two people at the Supreme Court that are lifetime appointments that can't even express themselves when they're being appointed. And that's sort of
and
where
they're
we're headed
usually
with this.
swing votes for justices who have no discernible judicial philosophy that they apply. That's why they're in the middle. That's why they're the swing vote. And yet someone like Kennedy or O'Connor serve as a swing vote for the entire nation. Let's send it up to Washington and see what Sandra Day O'Connor